welcome everybody to our bi-weekly webinar. I host this with Jim Brown, the founder of New Path Title, the awesome closing software Title Leap, and James Brown Law, the quintessential entrepreneur. My name's Ryan Poole. I'm a real estate agent, just like you all. Been doing this for over 20 years. I'm also the founder of RealTrade, which is an online marketplace and social media platform for real estate. We have thousands of agents on there, thousands of buyers and sellers, and awesome vendors like Jim on there, like Jeff Stewart here, a great lender on the platform. And our job here is to get you guys leads and help you connect with people to help you sell real estate and be more efficient. So definitely check that out. It's free for agents. Check out realtrade.io. And now I'm going to pass it over to my co-host, Jim, with New Path Title. This is an exciting topic. I mean, it's a real buzz right now with creative financing. You see all these crazy things on YouTube with Pace Morby and, I mean, I have my own listings now, people offering, sub two and creative financing. So you need to be, vigilant on this. There's a lot of misinformation out there. And we have Jim Brown that's going to clear these things up and give us some great information and that we can pass on to our clients.
So you guys, my main goal here is, first I want to tell you that this is my greatest pleasure, right? To be able to educate agents and get them to the point where they operate more efficiently and certainly less entanglement. And I want to start by saying what you hear here, what you hear in this platform are things you're not going to hear other places. I take great pain to find you guys content that you can't find every place else. There are no dumb questions. I'm going to try to get you out in 30 minutes. If you can turn on your cameras, it's great because then it's a small group. I can see your reactions. This stuff lives on YouTube and evergreen content, so it's all locatable. It's on our website. You can find it at newpathtitle.com. At the end, we'll have a question and answer session, but we're so small, we can do that throughout the session. And we're also going to give you some time-saving tools that'll keep you guys practicing more efficiently. All right, having said all that, let's jump right into it.
Awesome. If you have any questions too, as you go, you can raise your hand or you can just put in the chat, we'll try to get to them as we go.
And if you ever want to text me anything, go to newpathtitle.com. You can text me 24/7 and you can come up with new content for new shows. The nice thing about my position is I get agents calling me all the time on whatever people are calling me about. That's what we can make shows about. So here we have creative finance, seller mortgage, sub-2 wraps and assignments. For the first minute or two, I want to talk a little bit about the SITS or NAR update as of today. Been getting a lot of calls from agents. Can you come and educate us on the buyer's agency agreement? I want to lead by saying all the brokerages have been telling me, the major brokerages have been telling me they're going to have their own buyer's agency forms. I'm happy to come and educate anybody who wants to, and we'll do another session on the FAR forms.
Yes.
But the forms particular to your broker, I've received questions lately about what forms should I use. Here's the answer. In every transaction, whatever form your broker says is the form to use. So if you're in a boutique brokerage, I'm happy to educate you on what you need to know. I'm happy to go over the forms. And if you're in a large brokerage, ask your broker what you guys should use. And then very quickly, that form, the FAR form, will be revised and we'll go over it after it's been revised. But this isn't a bend in this isn't the end of the road. This is just a bend in the road.
So let me just quick question on that. So there, the FAR bar, buyer's brokerage agreement is still being edited. They haven't finalized that yet.
I think it's finalized for now, but I don't want to tell you it's not going to be revised for the deadline. So the deadline is August 17th, 2024. There's lots of buzz about changes to it, and I've heard no changes, and I've heard changes. I'd be more than willing to. I'd be willing to say that changes are coming to the standard FAR form. I think it's too long. My personal opinion, it's too long. It's too complex. And there's a couple of things in there that you can say that'll make the thing a lot easier to digest. The three big rules are simple: no buyer's agent compensation in the MLS, buyer's agency agreements, and commission disclosures. Here is the best 10 times over the top explanation of how you handle buyer's agency agreements. Don't get ahead of when you sit with your client, don't get ahead of your client on the topic. When meeting with buyers and sellers, don't mention the new NAR rules. Only bring it up if the buyer or the seller brings it up. If they bring it up, ask them what they know about it. Before you start spewing your dialogue, ask them what they know about it, because you could be dragging them into the deep end of the pool and you don't need to. And so all you're going to do is create more conversations. That's the single best piece of advice in all the dozen or so lectures and podcasts, no, dozen, several dozen. Listen to your client, address their issues, don't create new issues. And then when you've done, remind them that the recent NAR settlement did not create any new commission rules. It only created new practices for agents. And then remind them in the last 100 years that NAR has existed, commissions have always been negotiable.
It's true.
Pregnant pause. All you got to do is tell them there's no thing that's changed with the commissions. The only thing that's changed is how we have to work. Our practices, not the commission structures. And then here's the one I love. Put in front of your client 3 documents and tell them all 3 documents will govern the action of the parties. And then you put the documents right in front of them in this order. A listing agreement, this governs the sellers. A buyer's agreement, this governs the buyers. And the contract, this will govern when buyers and sellers agree. Now you've normalized every element of the transaction, you've made it tangible, and the person can wrap their head around the fact that they're not being singled out. This is what everybody in the deal is doing. I think these 2 pieces of information, they're not original thoughts. These 3 pieces, don't bring it up unless it's mentioned. Remind them that this isn't a commission change, this is a practicing change. And then you put the documents in front of the clients. I think that's huge as far as getting your goals accomplished and getting the agency of the buyer and then moving forward. And then we can talk about the details of the buyer's agency agreement later. All right, big takeaway on seller finance. Let's get into the main topic. Big takeaway on seller finance. Mark Twain said a long time ago, half truth is most cowardly of lies. I'm not trying to scare you guys in this one. I just want you to understand the gravity of entering into these sub-2 deals. I actually heard Ryan mentioned it earlier. I heard a Pace Morby interview live. They didn't edit this. And when it was originally aired, and they asked an agent how much she made in a transaction. It wasn't in Florida. And she disclosed she made $15,000. And then she asked the agent if it was an easy deal. The agent said yes. And then she asked the agent if they understood the transaction, and the agent said no. The agent said, you guys have great transaction coordinators, and I have a great transactions coordinator, but I didn't really understand what we were doing. It still lives on YouTube. It's out there. And so those are dangerous, potentially, situations. Always think about business leverage and who has the most to lose or win. Every deal you have to think about business leverage. We do it automatically, right? We're thinking about the buyer getting the property and the seller getting the money and the expiration of the inspection periods, and all those little things are business leverages. But in a sub-2 deal, and we'll go over exactly what sub-2 means, creative finance deal, who has the most at stake? The lender. In any deal, who has the deepest pockets to pursue bad actors? The lender. Who don't agents want to get on the wrong side of? Lenders. You guys, everybody thinks buyers are the biggest gorilla in the room, right? They're buying the property, they spent 500 grand. Who has the most money on the table in the deal? The lender.
Lenders. Yeah.
And that's who has the deepest resources, the deepest pockets, and the most offended in these sub-2 deals are the lenders. The number 1 rule in real estate and life, never deceive the person with the deepest pockets. And the problem is the success of almost all subject-to deals requires agents to not inform the seller's lender and not fully inform the seller. So now you've got the biggest player in the room, you have to offend to make a true sub-2 deal fly.
Yep.
Just
So
marinate on.
let's back up a second, Jim. I mean, just give the overall, the 30,000-foot version, because that's, obviously the buzz right now in creative financing is subject to. Just give, I guess we'll maybe get into that later on what an actual subject to deal is and what it involves.
No, I think it's a good idea. So what a subject to deal means is the seller is selling a property and the buyer is going to assume the loan of the seller. There's a whole section I went into deep dive on exactly the mechanics of a sub two. Let's stick to the outline for a minute, but we'll get into the.
No problem.
In general, a sub two deal is where the seller is selling a piece of property and the buyer is going to take the property subject to the seller's loan. It's pretty straightforward. And the thing that should be ringing out in everybody's mind loud and clear is, who is the seller obligated to even after they've let go of the property? The lender. That's the biggest problem. All right, why would a lender aggressively pursue agents who conduct these transactions? Subject to transactions are fraud and they deny lenders revenue and opportunity to lend at higher rates. Plain and simple. That's why the lender's upset. What do they do for a living? Lend money. Now they're locked into a rate that might be lower than they would have gotten otherwise. And Jeff, anything that I gloss over, don't hesitate for a second to chime in on. Behind lenders, who is the next party with the most exposure? Sellers. And here's the big problem that we're facing. And I'm already getting calls on this. Tort reform. There are lots more plaintiffs' lawyers looking for real estate agents to sue and get into their E&O policies. March 2023, Governor DeSantis signed a new law on tort reform, House Bill 8037, which is now driving lots of personal injury attorneys to look for new work. I'm already getting calls from lenders getting sued by plaintiffs' attorneys for deceptive practices, potentially deceptive practices. It's only a matter of time before these guys start, and women start getting to the pockets of the agents. So imagine a firm like Morgan & Morgan. They're doing business in Florida. Morgan & Morgan is the largest personal injury attorney in the state, in the country, thousands and thousands of attorneys. After tort reform, there was a deadline. Now all these lawyers are looking for lawsuits to file, and they only make money if they settle claims. And if agents have E&O policies, now all these plaintiffs' lawyers are running around looking for new claims. They're absolutely going to be trying to find sellers who did sub-2 deals, lenders who facilitated sub-2 deals, agents that facilitated sub-2 deals. All those parties are going to be targets for these plaintiffs' lawyers, and they're always looking for people with E&O policies because they can settle. Real estate agents have been found liable in cases involving sub-2 home sales transactions where the buyers take over the existing mortgage payments from the seller without the consent of the seller's lender. So there's a good working definition. Buyers take over existing mortgage payments from sellers without the consent of the seller's lender. What are the sources of liability? Failure to disclose material facts. That's pretty obvious. Real estate agents have a duty to disclose known material facts that may affect the value of the property and are not readily observable to the buyer. Failing to disclose that a subject to deal violates the mortgagee's due on sale clause could be considered a material non-disclosure exposing agent liability. That's pretty straightforward. We're going to get into what the due on sale clause means in a minute. Every agent I've ever talked to about this topic says the same thing. It's in the public record. Why do I have to disclose it? Why? Because two reasons. You're held to a higher standard, and transparency is something it's expected of agents, and you guys signed up for it in your oath of agents. And two, who wants to argue that point in court? Like, from a practical perspective, who wants to try to sell a sub-2 deal knowing that the due on sale clause is in the public record, but now you're in court arguing why you don't have to disclose it? Who wants to be in that position? Nobody. Fraudulent, what are some of the other reasons agents can be liable? Fraudulent or negligent misrepresentation. If an agent affirmatively represents or provides inaccurate or incomplete information about the legality or the risks of a subject to transaction, they could face claims of fraudulent or negligent misrepresentation. Omission, think back to what Mark Twain said, omission is just the same thing as lying. Breach of fiduciary duty, everybody can understand that one. When acting as a buyer's or a seller's agent, the real estate professional has a fiduciary duty. It just goes without saying. Violation of licensing laws, engaging or recommending subject to transactions that violate mortgage contracts or real estate laws, regulations could expose agents to disciplinary action or liability for violating their professional duties. That's obvious. Contractual liabilities. Here's one that people don't think about. While listing agreements often have hold harmless clauses, courts have found that these cannot shield agents from liability for omission or misrepresentation. Anything you do, any disclosure you give is going to be vacated if you've failed to reveal all the facts or misrepresented facts. What is the due on sale clause? Almost all mortgages have a statement that reads, this is one of the most important takeaways from this lecture, from this discussion today. If all, and if you look, it's either paragraph 23 or 27 for some reason in almost all mortgages, commercial lenders. If all are part of the property here.
Mortgage is assumable.
Is that, were you Ryan? No?
No, Susan, you had a question?
All right.
Keep
If
going.
all, so in every mortgage, there's this clause. If in almost every mortgage, if all, or and including hard money loans, if all or any part of the property herein is transferred without the lender's prior written consent, the lender may, at its option, require all sums secured hereby immediately due and payable. There's also a provision in the mortgage that says in almost every mortgage for enforcement actions, the seller, the borrower, who is the seller in a sub-2 deal, is going to pay the reasonable attorney's fees costs of the lender. So now you've agreed that if you're going to transfer the property, you're going to pay off the loan. And if the lender has to go after you, you're going to pay the lender's fees. And now you're the seller in a sub-2 deal. Wow. In short, if the seller leaves title, the lender can call the loan. All subject-to deals I've seen require the seller to leave title and the seller's lender not be informed. You know, I don't want to stress this enough, but how can this be? And how can, and here's how it can be. Anybody can put anything on the web. Anything can put anybody can put anything on social media. But I think you're going to see as time goes on, and Jeff, again, if this is a discussion that you guys have at the lender level, I'd love to hear about it. I think you're going to see major problems, lawsuits, violations of law, including criminal law, against some of these organizers of these transactions. How does a seller lender find out about the transfer from the seller to the buyer? Taxes. No brainer. When the lender checks taxes, lender will see a change in the title holder. There's your first trigger. They will see a change in the tax value. For the very first time, I've been practicing law solo for 20 years, almost 20 years, and been working in real estate for 40. I have never myself thought and talked and pondered the whole concept of the trigger being the change in taxes. So if your seller was somebody in financial distress, not always, but chances were it was a homestead. And when they sell to the buyer, you're going to get a massive retax trigger, escalation, jump. We talked about it a couple of weeks ago. The trigger is going to recalculate the escrows. Somebody's going to have to sit there and burn calories and figure out what the new tax bill is, punch the keys, enter the codes, and you don't think that's going to go off in their heads that there was a situation here that triggered the tax jump? Even if it's not their homestead and the seller held the property for a number of years, taxes are held artificially low, not as low as they would have been with homestead, but they're artificially low. That's going to trigger a jump in taxes. That's going to trigger the lender's clerk to take a deeper dive look at this thing. And if you don't think that using AI to put transactions on the radar, that's just naive. Insurance, when
Hey,
lenders,
Jim,
yep.
is this initially, it, I might be going down the wrong road. Is these all fraudulent intent for these things that happen?
You know, I'd hate to paint with that broad a brush. But just looking at it from the seller, if the seller agreed in a contract that they're gonna do one thing and then they do something else, that's not a fraud, that's a breach of contract, right? The seller agreed that if we sell the property, we're gonna pay off the loan. That's not a fraud, that's a contract breach, but there's damages as a result. But when you start bringing in other people and when agents start advising on how to keep out of trouble by not triggering the due on sale clause, where we'll get into in a minute, those are misrepresentations and fraud, potentially frauds. And there's some pretty compelling stuff on YouTube from people that are purportedly experts that are we'll go over in a second, that absolutely lead people down paths, consumers down paths that I think will have huge repercussions for the people creating that content. Did that answer your question, Jeff? Like, the seller is a breach of contract.
Yeah, I mean,
But everybody else in the chain of the transaction, they're facilitating the breach and potentially committing a fraud.
Yeah.
Including the insurance agent who will go over in a minute, who has this great advice on how to obtain insurance. Mind officially blown. I cannot even believe they're doing this, like putting this stuff out on the web. So when a lender sees a new insurance policy with a new owner, that's going to be a trigger, right?
Yeah. Alberto, I mean, he just had are sub twos legal or illegal?
A sub-2 deal is a civil violation. You have a contract. If you're a seller, a sub-2 is a civil agreement and it has civil liability. Criminal liability is a much higher standard. But if you're an agent and you're if you're a real estate agent or an insurance agent, certainly, and you're facilitating a sub-2 deal, and you're not giving fully transparent information, that could rise to criminal activity. So the bar for civil liability is here, and that's usually a contract or breach of a contract, and the only remedy is money. And criminal liability is up here, much harder to prove, but there can be money and it can be jail time, incarceration. So the threshold for criminal liability is higher, although how can, if you're committing fraud and criminal liability are like coupled. I don't do that kind of work for a living, but I know enough to say, if you're omitting enough or you're misrepresenting enough, that's fraud and that's going to be criminal. And when an insurance lender sees a new policy with a new owner, they suggest in these videos, they suggest there's one alternative is to pay two policies, the seller's policy of the owner and the buyer's independent policy. First, it's expensive, but what's the goal in paying the two policies? To mislead. What's the goal of paying the two policies? To mislead the lender into believing that the seller hasn't left title. We'll go into that more in a minute. Insurance companies are advertising themselves as sub-2 experts. I found no non-credible that did not require concealment from the banks. I've had people come into my office and they said there's sub-2 insurance for sellers, and that's insurance that pays the seller if the buyer defaults. I can't find any of them credible. And now there's a proliferation of insurance agents on the web that are saying, we can insure your sub-2 deals. And this is the best advice I could come up with. Some recommend you list the new owner as the primary mortgagee and the old owner as the primary. Should not be a comma there. This is an actual statement from one of their videos. And the old owner is the additionally insured and the buyer becomes the primary insured. and rely on the ignorance of the clerk reviewing the file at the lender's office to not call out a red flag. You can watch the video I gave you, fast forward to 5 minutes.
Jim, I thought the additionally insured would be the lender.
That would be the mortgagee. So the way they call it out in this one particular video, they're suggesting you leave the buyer as the primary insured, the seller that's being taken out of title is an additionally insured, and the mortgagee stays the same mortgagee. But they're suggesting that the clerk, as long as the clerk at the lender's office sees the seller's name on the policy someplace, they don't call out a red flag. I can't see that. That doesn't make sense to me. Some advise the buyers to keep the insurance in the seller's name and take an assignment of insurance proceeds. In an assignment of insurance proceeds, so Ryan is the seller, I'm the buyer, Ryan signs an agreement, and I've seen this all the time in a number of different transactions, that Ryan, if he gets any money in an insurance loss, he's going to give me the money. What if there's a claim and the seller is not locatable? What if I can't find Ryan when there's a claim? What if the insurance company pays Ryan and then Ryan refuses to pay me? Now I have to sue Ryan for my remedy? How does that even, you know what I'm saying? Ryan just got a windfall. He sold a property a long time ago. 50 grand lands in his pocket. Is he really going to be eager to pay me? Why would insurance companies pay a prior owner if they are not in the title at the time of the loss? Do you think an insurance company, from a pragmatic perspective, is not going to take 2 seconds to figure out if Ryan is still in title? And when they see Jim is in title, not Ryan, they're actually going to cut a check? It defies logic. So to summarize, there are two ways that these people are suggesting you get around the issue. You get a new policy naming the seller as the additionally insured, or you pay the original policy and buy a second policy naming buyer as primary and don't give this to the lender. Do you guys see a pattern here? Don't disclose.
Yep.
Stop, full pause, don't disclose. Nobody ever got in trouble for being 100% transparent. You might get a slap on the wrist. You might get a buyer that doesn't want to do a transaction. You might get a seller that doesn't want to do a transaction, but nothing is worth your license. There are ways to do these deals though. YouTube is dangerous. Please think critically. Some insurance agent goes so far as to tell the real estate agents to wait until things cool down to give the new policy. Well, you know, you guys, I've had real estate agents toe to toe with me about these issues. The clerk at the lender's office has no idea what they're looking at. This is what some of the YouTubers are saying. They're relying on the clerk at the lender's office having no clue what they're doing to make this deal successful. Sorry, I do not want to rest my license on the omission of some poor clerk at a lender's office. One insurance even gives coaches, real estate agents and buyers on what to say if a lender questions their role in the deal. And they suggest you tell the lender you're the asset manager. You're somebody who was put in place by the seller. You're like, the level of misguidance blows my mind. Don't think for a minute lenders are not implementing AI to watch this stuff. Did I find this anywhere? No. But how much AI do I use in my daily life? Why would we think for a minute lenders aren't? Always think about your exposure as an agent. The lender is deceived. The seller has ongoing liability under the note, and the buyer could lose their equity. How to do these deals legally and lawfully? Assignment. How do you do these deals without getting in trouble? Assignment. Government-backed loans like FHA. I did not know this until I started researching for this podcast. Government-backed loan, I've heard it, but it just didn't resonate with me over the years. Government-backed loans like FHA, VA, and USDA loans are generally assumable, meaning the mortgage can be transferred from the current owner to the new buyer with the original terms remaining in place. It just takes the right loan and a lot of patience. We did one the other day, Jeff, I don't know if you're seeing them. We did one the other day and the loan was assumed. It took forever, and the underwriter was the lender, not a local agent. and it went through, and the seller was released of liability.
Hey, Jim, I have never done one of these assumable FHHs, but how does it get through the title process? All these, I mean, isn't that something you guys catch for as a most part, or?
In a subject to deal,
Yeah,
in a subject to deal, that's a great question. Let me just finish this and then we'll jump right into that. Hard money lenders also like to lend. They don't like to collect, and they are predisposed to extend to the new buyer. Hard money lenders love to extend. So if you got it, and we're seeing way more hard money lenders. We're closing a couple this week, several this week. If you're a lender and you're an agent on the existing transaction, you ask your seller, do you mind extending? Because it's going to open up the broad spectrum of possibilities to potential buyers. Now, on Jeff's question, yes, if title is going to transfer subject to a mortgage, your title insurance commitment received by all parties is going to have an exception for the mortgage. If title transfers subject to a mortgage, Schedule B2 is going to have an exception that says the mortgage from, the mortgage with Chase Bank or something as an exception, right? So everybody takes title and everybody's aware. Now, it's not like the title agent can sneak it in because it's going to be an obligation of the buyer. Everybody knows that. But it is going to be memorialized someplace and everybody has to take an affirmative. It's not like it could just slide in under the radar. And you bring up another good point, and that is, I heard a podcast, unfortunately, this won't be in the outline, but I heard a podcast the other day where they were talking about how to do second mortgage creative financing. And as soon as you put this stuff on the web, people start calling me about it, and I'm waiting for the phone calls. And so what the real estate agent was suggesting was, not suggesting, they were saying to do is find a title agent who will sit on the seller's contribution and the buyer's contribution. So now you got a $500,000 deal and a $450,000 loan, and you find somebody who will give a second note for that $50,000. And so this was specifically a creative solution in the world of creative finance for buyers who didn't want to bring any money to the table. So the buyer basically brings the 50 grand, parks it temporarily, closes, the title agent closes the first loan, then they pay the 50 grand back to the buyer and somebody else comes in and writes the second mortgage. They're finding, I would imagine they're finding title agents who will do this because they're advertising it and selling packages. I can't scratch my head and wonder why, if you're making so much money doing this stuff, why are you selling packages for other people to do it? But the reality is, it sounds like there are title agents who are doing this. And that's a title agent. So now you've got the buyer, it's a whole nother set of facts because you have a new lender for the first position, but now you're drafting the second mortgage and you've got to find a title agent who's willing to do it and not reveal it to the first mortgage lender. I guess it's happening. If you guys hear about this stuff, I'd love to hear about it.
Yep. So, Alberto has a quick question in the chat. How are loans assumed? What's the process?
You make an application. You make an application to the lender. I don't know if there's a website or a portal or something, but you make an application.
Yeah. The best luck that I've heard actually are the easiest to assume are VA loans. There's a lot of VA loans with low interest rates that were made during COVID, and obviously that's advantageous for a lot of buyers out there looking to get a deal and get a low interest rate, right? And of course, the property went up, they can pay that delta and then take over the mortgage.
Well, that's a great point, Ryan. So on your listing appointment, you see your seller has a loan, and if you get a title advance, you can see what kind of loan it is.
Correct.
And you could go out there and you could talk to one of the talking points for your listing could be, it's an assumable VA loan. It's an assumable FHA loan. It's one of these loans that we talked about. FHA, VA, and USDA loan. that shows your value. Even if you don't, even if it's got the wrong loan, if that's part of your listing pitch, you're gonna seem like the most sophisticated agent. That's a great value add right there. I mean, that's gold. That one little takeaway that Ryan just brought up is gold. There are 4 general categories of creative finance. Now we'll get into the podcast that I've done in the past. A seller money mortgage, a seller money mortgage. Title transfers the buyer and the seller lends money for the purchase in the form of a note and a mortgage. That's pretty straightforward. I'm going to show you guys some nuances on the form that everybody has to use to do that. Subject to is what we were talking about. The title transfer is subject to the mortgage. A wraparound mortgage is just like a sub two, but the seller has a second position on the note mortgage on the buyer's property, and the buyer makes the mortgage payments to the seller, and the seller pays the mortgage, pays the existing seller's note mortgage. Does it require some level of complicity of all the parties, agents, title agents, and everybody? Yeah. But they're being done. Assignments of mortgage and title. This is the one that we talked about with the VA and the FHA and the USDA. Title transfers the buyer and seller's mortgage is transferred to the buyer and held in the buyer's name. Seller's name comes off note and mortgage. The point that Ryan made is the most important point. Your buyer could be getting into a position where their payments are going more towards principal than interest, and they're potentially at a lot lower interest rate. That property could even sell at a premium. That property could even sell at a premium. So let's get into the seller money mortgage. If you're going to do a seller money mortgage, you're going to want to have this form signed. You're going to want to read over the exclusions of when a seller can be a mortgage lender. And if you pass all the exclusions, then your seller can be a mortgage lender. Generally speaking, if you didn't build the property to sell it, or you didn't rehab the property to sell it, and you're only going to do this 1 to 3 times a year, then you could be a seller lender. Sellers who finance the buyer's purchase of the residential property who meet either of these 2 exclusions may use the seller financing rider.
I'm seeing in the MLS. I'm actually, obviously the best candidate for that would be a seller finance, would be a seller that bought a long time ago, paid off their mortgage. I've seen a lot of these properties that are offering seller financing because the property traditionally might not be financeable. Might need a new roof, or the kitchen's ripped out. I just saw one the other day where the kitchen was ripped out.
Yeah, the seller gets probably 30-40% up front.
Yep.
They finance, they don't have a whole lot to lose.
Yep.
Almost a hard money loan, really.
Yeah. There's a whole bunch of clauses in the bottom of the refinance, in the bottom of the seller finance addendum. It's pretty specific. You're gonna have to pay close attention to it if you're gonna use it. I don't agree with some of the provisions, like your seller can be late 30 days before there's a default. So you're going to want to read this over and clean it up. Certainly 15 days is acceptable. But 30 days for a first mortgage, that's crazy to me. And 15 days if it's a second mortgage. So you could actually do seller financing of a second mortgage if it's disclosed to your first mortgage lender. So we talked a little bit a minute ago about transactions that I don't approve of, that where the first mortgage lender isn't being told there's a second mortgage. If you're going to do a second mortgage with the seller bringing money to the table, or giving money at the table, you disclose it to the first mortgage lender. It's on the settlement statement. That's not a problem, as long as the first mortgage lender doesn't squash it. We're at 45 minutes. I want to pick out some seller money mortgage stuff that I think is important. Well, you want to get your title advance so you can see what the value of the mortgage is that's getting paid off. You always want to know what the equity is. But if you take a few minutes to research the mortgage, you can see if it falls into one of those categories. A lot of people call me and they say, who owns the property after a seller money mortgage? Think of a seller money mortgage just like any other mortgage. Who would do this deal? And the person who would do this deal is the person who's probably been in the property a little bit longer, doesn't necessarily need the cash at the closing table. These are all things that you can come up with as listing agents to pitch yourself and add your value when you're talking to your seller at the listing appointment.
Another nice thing too, like I've done some seller finance deals, is for the seller's perspective, right? They don't have a big taxable event from the sale, right? So
Well,
they say, you know what I
yeah.
mean? Yep.
So why is that? The reason is because you don't pay the capital gains at the time of sale. You pay the capital gains over time as the payments come in. So the seller doesn't have this big tax burden. So think about fact patterns when that would be valuable. Sellers own the property for a long time and it's not their primary. They're going to get whacked with a big tax. Now they can defer that tax into the future. Again, you look at the property, you understand a little bit about who your seller is, the profile of your seller when you walk into the listing appointment, and you're gonna look like a rock star. Does it take preparation? Absolutely. But we're in a hyper competitive environment. You need every little advantage you can get. Also look at the value of the mortgage that's getting paid off. You can even have a cash flush seller without a lot of equity can even put money into a deal to make a loan if the buyer and they receive more money over time. I heard an interesting discussion and it was about seller money mortgage. And so some of these lenders are giving seller money mortgages, and instead of collecting interest, they're instead of collecting high interest rates, they're giving overinflated values. In other words, they're getting their overinflated price. In other words, if the house traded for 500 grand in the neighborhood all day and night, they're asking for $550,000 and they're taking a lower interest rate. It's just another way to skin the cat. There's advantages to buyers and advantages to sellers. The single biggest mortgage pitfall I ever see on seller money mortgages: don't overlend. Whenever you're seeing a loan amount and the seller and the buyer are going to ask you, how much should I lend? How much should I borrow? If you're advising sellers, the good rule of thumb is not over 70%. That's not a rule etched in stone anywhere. It's just if value is correct, you want to make sure that your seller is covered. They're not exposed. You want to make sure that the buyer comes to the table with some money in their pocket. Dog in the fight, skin in the game. The buyer who comes to the table and they're not paying anything, and they're gonna they're gonna get a loan for the first position, and they're gonna give the seller money mortgage on the second position, and they're not coming to the table with any money. Anything goes south in their transaction, they're gonna bail, especially if they don't have personal liability. I saw a YouTube video where the gentleman Ryan mentioned earlier boiled down all the parties in the transaction and who was going to get money in the transaction. And basically, at the end of the day, the buyer wasn't bringing any money to the table, but there was a transaction coordinator that was making a good amount of money, a realtor that was making a good amount of money. The seller didn't make hardly anything, or maybe they even made nothing. And there was just a bunch of people in the chain that were making money. And the buyer was looking at a zero-sum gain on the monthly payments. So the buyer was flush every month. But what happens when insurance goes up? What happens when taxes go up? I mean, these are all I couldn't even put together how the transaction made sense. Forget about replacing a roof. And if you're overpaying for the property, like the example we were talking about, and the reason this example came up was because the consultant was trying to explain, the YouTuber was trying to explain to the audience how paying more for the property was acceptable. They're not even building equity.
I mean, what do they hope? The only thing that they're hoping for is, that they get some kind of cash flow, right? I mean, that's, on the subject.
There was no cash flow in the deal, Ryan.
I mean, why would you ever think of doing that? I mean, there's no equity or no cash flow. It just doesn't make sense.
Here's who was getting paid: the realtor, the transactions coordinator, And somebody else they had in the deal that was, I mean, they all walked away with significant cash. And they even found a hard money lender, according to the example, to do the second position. To me, it defies logic. I want to see it explained, and I want to see a bunch of successful examples, but I can't. I don't see it. Typical loan terms in a seller money mortgage, 70 to 95% LTV. You don't want to go above 70, in my opinion. 4 to 10% interest in a 30-year amortization. No prepayment penalties. In the seller's financing disclosure, there's a statement in there about no prepayment penalties. That's something I particularly think should be in there. You should get some kind of a bump in money if the seller's going to pay, if the buyer's going to pay off early. Here's the terms that I think are safe, like we talked about before: 70% LTV, 8 to 12% interest in a 1 to 30-year term. I like interest only, not amortized. I like interest only because nobody gets the amortization right. And then buyers calling me and sellers calling me and they're upset, and a prepayment penalty in the first 1 to 3 years. And this is what Ryan was talking about earlier. Is everybody clear on what sub 2 deals? We're at 50 minutes now. Is everybody clear on what sub 2 deals are? We can go on to this forever. I've created an outline. I'm going to share it with you guys. It'll get mailed to you at the end. I want to be respectful of your time, and I don't typically want to scare people into action, but I think in this particular topic, I think it warrants a lot of thought before you guys do these kind of deals. And the thing you want to, in the back of your mind, you want to think about is transparency. Whether it's a sub 2 deal, whether it's any deal, you want to think about transparency. There's a provision in the contract under seller's disclosures, which says sellers sellers and agents for the seller have to disclose whatever is known to seller, not readily observable, and materially affects value. Those 3 things are the disclosure test, and they're right in the contract. But you guys should just always have that stuff resonating in your head, and you'll stay out of trouble that way. You'll stay out of problems. All right.
Awesome, Jim. Great job on that. Thanks for bringing some clarity. Obviously, the red flag is going to go up subject to deals. I've had them on my own listings. Pay attention. Best way to do it is the assignments. To sign the loan, right? That would be probably your easiest one. There's the wraparound option as well, and of course, seller finance. And I've done seller finances deals myself, so those are all great information that we can rely on. And thanks too also on the on the NAR settlement at the beginning, Jim. So thank you guys. We host this bi-weekly webinar.
I want to mention one more thing. When you were talking, it brought back an old transaction into my mind. So we did a transaction where the seller sold for several $100,000. They sold subject to, there was no money exchanged. I think the buyer gave a couple of grand to the real estate agent. It was a subject to sale. Nobody could get financing, and the property was dying on the vine. And so the buyer goes into title, and they rented the property for several years. And they never paid the mortgage. They never did anything. And they rented the property for 2 years before the lender foreclosed. And they actually defended the foreclosure on behalf of the seller to postpone so they could rent for a longer period of time. And now the seller caught wind of the foreclosure. They had left the area, obviously, and were having a hard time getting located. And I forget how the seller got located. But by the time they came back into the deal, the mortgage balance was dramatically higher. The property was radically degraded. And the seller in the sub 2 deal had a mess. So that's a real world scenario. That was from the earlier 2010 mortgage foreclosure crisis scenario. But all that stuff is just, I have PTSD from all of it. So anyways, one lingering thought on the whole sub 2 thing, you guys. It's legal, just like Ryan said, but assignments are the way to go, or seller financing. That's the way to go.
Awesome, Jim. Well, thanks everybody for attending. Like you said, check out Real Trade if you can. You can just Google Real Trade and you get free leads. It's free for agents. We actually have an awesome premium agent feature now that we have. Frederico, take advantage of that with the new AI assistant. I know you were on the last webinar. And yeah, check out Jim. Jim, I can't say enough good things about Jim and his shop with Title Advance. You know, New Path Title has their own closing software called Title Leap. It's like a free transaction coordinator. I use it all the time, literally on every single deal now while I'm representing the buyer or the seller. You want to know what's on title. You want to know the payoff. You want to know that valuable information going into it, which is incredible. So, you know, you want to know all that kind of information with Title Advance. Nice thing is it's free for agents. You know, it's free for agents to use Title Advance, which is great.
And if you guys need to, and we find there's a problem property that's more in depth than a title advance can reveal, and we found a lot of this stuff lately, you can go on our website and you can order title products. And you can either get a title advance or a title commitment. Is my screen showing, Ryan?
Yep, you can see it.
Or you can order a municipal lien search, and I'll credit you back the value of these searches at the closing. So now you'll have the tools that we have to close your files efficiently. We also can arrange for hard money loans. And we
You help with seller finance deals too. Can you help with the mortgages, setting those up on the seller finance, Jim?
Yeah, we can absolutely advise on seller finance deals. We can do the things that we can fill the gaps that you guys have in your knowledge to get those deals done for sure. Don't feel like you got to know all the answers, but do feel like you need to know the issues. So my goal is to not necessarily tell you every answer, but my goal is to put your radar up when there's an issue so you guys don't get into trouble. But more importantly, we can figure out a resolution and get you guys closed. All right. That's all I got.
Awesome, Jim.
Sell a
Thanks,
bunch of
everybody.
property. You
Good
bet.
luck out there. Happy selling.
Thank you.